It's my pleasure to introduce Kelly Crawford. Kelly Crawford grew up in the Los Angeles area, went to University of California, Santa Cruz. So as I joked with him, go Banana Slugs, the famous mascot of UC Santa Cruz. He received his BA in history in 2011, and upon graduation, he enlisted in the United States Navy. He spent a tour of duty in Sasebo, Japan, and in the Western Pacific, mostly hauling Marines like me around the Western Pacific in LCUs. And then after the end of his time as an enlisted sailor doing that, he applied for Officer Candidate School and was commissioned as Surface Worker Officer, serving another tour, I believe, 5 years in the United States Navy as a Surface Warfare Officer, Gunnery Officer, and Navigator on Ticonderoga class cruisers. His service included Western Pacific cruises, Persian Gulf cruises, and a considerable amount of time aboard ship, from what I understand. He is a Fletcher class of 23 alumnus, and since leaving Fletcher, he started and co-founded an organization called Forward Horizon Group, where he serves as the Chief Operations Officer. Forward Horizon Group is a frontier markets security and consulting firm with a mission to bolster democratic resilience. He also has a Substack or a blog called Pioneering Oversight, which is a weekly newsletter on emerging technology and governance. He tells me that he's been admitted to law school and he'll be enrolling at the University of Washington in Seattle in the fall.
Oh, right.
Thanks to you guys.
Welcome, everyone. It's fantastic to be here. I can't think of a better way to start off a Fletcher's 90th reunion with a discussion on the free marketplace of ideas and free speech. So thank you all for coming out. And thank you, Professor Glennon. It's an honor to be up here with you. This was one of the last classes I took at Fletcher up at the Murrow Room. And it was a classic Fletcher class in a lot of ways. Dealt with controversial, complex topics in foreign relations and constitutional law. We got to sit across from each other and debate with peers these issues, and also sometimes debate the man who quite literally wrote the book on the topic himself. One of the other things that made it so special is that, Professor Glennon is a part scholar and part practitioner, beginning his career after law school on Capitol Hill, starting at the House of Representatives and then working his way up to the Senate, Senate Foreign Relations Committee, where he's lead counsel, and the Senate Judiciary Committee. He advised senators and future presidents of the United States on topics like presidential war powers and international treaty interpretation. Sometimes they valued his advice and counsel so much they invited him to do this in the privacy of their home. So we truly have an expert in constitutional law here with us today. After a very successful career on Capitol Hill, he went on to become an academic, beginning at NYU, moving on to the University of Cincinnati, UC Davis, spent quite a few years as a visiting professor at University of Paris too in France. And I think we can all say made the stellar career move to come here to Fletcher to be a professor of constitutional law and international affairs. He's written plenty of books along the way. One aptly named in his area of expertise, constitutional diplomacy. Another one, which I recommend as a companion piece of the book we're going to talk about today, National Security and Double Government, which I look at as very much a prequel to some of the issues Professor Glennon is going to bring up. As Skip said, Professor Glennon is going to give some overhead remarks on free speech and turbulent freedom. Then we'll go into a Q&A with myself and then open it up to the audience for questions. And there'll be a book signing and an opportunity to purchase the book right here afterwards. So without further ado, please join me in welcome Michael Glennon.
Kelly, thank you very much for those kind words. Kelly was a star student in not only my seminar, but in the Fletcher School at large, and those words have particular meaning for me, and I very much appreciate them. I don't think I've ever seen so many members of the Fletcher Mafia all in one room. This is a real treat. I mean, the FBI could have a few. I'm sorry. Somebody told me we're not supposed to call you the Mafia anymore. Speaking of freedom of speech, I want to, in just a few minutes, touch on three of the central themes in this book that was just published. Free Speech and Turbulent Freedom. First, why censorship is a bad idea. Second, why I think some people still seem to be seduced by that idea. And third, why the First Amendment, which a lot of people these days think is antiquated. So to begin at the beginning, why reject censorship? Beginning of World War II, the British made a very pleasing and interesting discovery. They had been beaming Churchill's speeches into Nazi Germany. And they wondered how many people were listening. The Germans were, for some reason, unable technologically to block the speeches, the broadcast of the BBC. But of course, if the Gestapo heard you listening to the BBC, you were in deep trouble. So they wondered, how many people actually listened to Churchill's speeches. They had a good test group, captured Luftwaffe officers who had been captured when their planes were shot down during the Blitz, the bombing of London. So they asked these pilots whether they listened to Churchill's speeches. Overwhelmingly, the pilots said yes, they did. And these were some of the most loyal members of the Third Reich, of course. I mention this because it highlights, as I say, one central theme of the book, which is censorship doesn't work, or more specifically, the costs of censorship far outweigh the benefits. It's not that the speech, falsehoods, etc., is harmless. It's that the effort to suppress that speech is more harmful, that it leads to political instability. Censorship, Brandeis said, menaces stable government. What did he mean? Think about the effects of censorship. First, it discredits the censor, just as it discredited the German government. It distrusts the people, and the people distrust it. They don't believe what the censor says because the censor isn't squaring with them. It doesn't believe they can handle the truth. It makes martyrs out of the individuals who are censored. They become heroes, and as a result, their messages tend to be valued more than they otherwise would. They have a forbidden fruit quality, just as Churchill's speeches did. If you are strong enough in your belief that what you're doing is right, you can withstand criticism. So the German pilots wondered, what is it about Churchill's speeches? What's he saying that the German authorities don't want us to hear? It drives this censored speech underground, where it's harder to refute, or where it doesn't get rebutted at all. And the censors in the process go into overdrive. Some people think, well, these are philosopher kings who know better than the rest of us what we should see and hear and think. And they are, as a result, somehow immune from the usual cognitive distortions that inflict themselves on the body politic in general. But no, these people are subject to exactly the same cognitive distortions as the rest of us, and then some. Because it's a small, insular group with great esprit de corps, usually, that meets in secret. And they inevitably, as I say, go into overdrive. Most importantly, censorship implies subordinated minorities of the two most essential in breaking the chains of their subordination. And you find historically that every subordinated group finally succeeded in getting into the mainstream of society. Did that because it was able to get its message out through a free press and free speech. Abolitionists, suffragettes, the women's rights movement, the civil rights movement, the gay rights movement, they all relied on freedom of the press. John Lewis, the great civil rights leader, said, the civil rights movement would have been a bird without wings had it not been for the free press. So again, I underscore this. It's not that the speech in question is harmless. No, everybody recognizes that some hate speech or falsehoods can be harmful. It's that trying to suppress it menaces stable government. You can see this by my dad vividly in the case of the United States. We don't have a totalitarian regime like Nazi Germany, where it's possible to block out almost everything that the censors would like us not to hear. People know what's going on, and they discover that there are other ways to get at censored material. So you have one group in society that is aware of the messages that are being suppressed, and another group who has no idea what they're talking about. That leads to a polarized society that menaces stable government. And we see it happening before our eyes. So, why do some people still get seduced by censorship? I had a few years ago an interesting insight into the mind of the censor. I was invited to meet with the Communist Party Central Committee in Havana, Cuba, to talk about their government and our government and the relationship between the two governments, with a small group of law professors. So over the course of a week, all of us sat on opposite sides of the table and listened to each other in what were supposedly candid conversations. And as you would expect, the Cubans didn't have a lot of criticism of their government. They had a lot of criticism of the United States government. And midway through the week, I said to the guy who was running this thing, who was the intellectual architect of the official regime doctrine, very bright guy. I said to him, you know, I've got a question. I go down to the newsstand in our hotel, and I can't find anything that criticizes the Cuban government. I can't find anything that criticizes any of the policies of the Cuban government. I can't find anything that criticizes any of you or anybody else in the Cuban government. What's the problem? I mean, if you're that confident in what you're doing, why don't you allow people to criticize it? His response has always stood out in my mind. He said, we don't allow criticism because we have made the judgment that our revolution is correct. We know that we're doing the right thing. And if we were to allow criticism of what we're doing, it could only lead to mistakes and error and confusion. This stuck out in my mind because it is the perfect example of what Justice Oliver Wendell Holmes was referring to when he said, it makes perfect sense to persecute the opinion that you dislike if you are completely confident of your premises. If you think that you know the truth beyond any doubt, that you have a monopoly on absolute, universal, timeless, objective truth, that your opponent is the physical embodiment of evil, that there is one defensible, legitimate vision of social justice, you know what it is, your opponents don't, then it makes sense not only to persecute opposing opinion, but as Holmes said, to engage in violence to prevent them from coming to power. Why? Because sitting down and reasoning together is no longer an alternative method of resolving differences. Violence is the only solution. If, on the other hand, one approaches these issues with a modicum of epistemic humility and recognizes that none of us is infallible. We all make mistakes. Our opponent could be right about something. There might be a nugget of truth in what those people are saying. There might be more than one vision of social justice that is legitimate. Then we believe in political pluralism. Political pluralism, which is embodied in the First Amendment of the United States Constitution today. Why the First Amendment? Why the First Amendment? You know, there's a growing school of thought that has it that this 233-year-old flat-out prohibition against abridging freedom of speech and the press is outdated. A growing school of thought that we need to get with the times, get with modern fashions, look to something more stylish, like international human rights law. That is, in fact, what the American social media platforms do in content moderation, in determining what to bury, what to suppress. They don't look to the First Amendment. They look to international human rights law. So, for example, Facebook is confronted with this question: should we suspend a president of the United States for a statement made on this American channel of communication to Americans on a subject of political interest in the United States? And the answer given by these experts in Silicon Valley who have advanced degrees in STEM studies and know much more about the First Amendment than Jefferson or Madison or Holmes or Brandeis. The answer is, this is to be decided not by the First Amendment, not by the hundreds of cases decided by the United States Supreme Court over the course of 200 years, but rather by cherry-picked treaty provisions, resolutions, customary norms from international human rights law. So what's wrong with that? Why not look to a more modern body of law, such as international human rights law? I've had a exposure to international fashions in global respect for free speech a few years back, when I testified for the country of Nicaragua in a case that had been brought before the International Court of Justice against the United States for trying to overthrow its government in clear violation of international law. I say brought by Nicaragua. The truth is that from start to finish, it was an American case. It was brought by American lawyers. The case was conceived of and organized by Paul Reichler, a Washington lawyer who represented Nicaragua. The lead counsel in the case was Abe Chase of the Harvard Law School, probably the most prominent international lawyer in the United States, if not the world. He was the top lawyer in the State Department during the Kennedy administration, legal advisor to ex-con during the Cuban Missile Crisis. The lead witness in the case was a prominent former CIA analyst, David McMichael, who testified in great detail about the relationship between the CIA and the Contras and what the CIA was doing in Central America. I testified about findings of an on-site human rights investigation that looked at the activities of the Contras in the war zone of Nicaragua. We found it would be understating the case to say that we found that the Contras were engaged in a consistent pattern of gross human rights violations. The Contras were engaged in what can only be called terrorism. They were terrorists. President Reagan said to the American people that they were the moral equals of the founding fathers. That was not true. And all the evidence before the court, and it was overwhelming and devastating, established that that was not true. So this case was a very, very big deal in Europe. It was spread all over the European papers, front page stories, day after day after day, while the trial was going on. I was in The Hague, of course, at the time. It was extremely embarrassing to the United States. And yet there was surprisingly almost no mention of this in the Soviet press. Nary a word. Question, why would that be? I think I know the answer. I'll tell you. When I stepped out of the courtroom after testifying, I was surrounded by, as reporters and cameramen, and this young Polish law student elbowed his way to the front. He was, kind of bewildered, and he looked a little dazed, and he stuck his finger in my chest and he said, "You can say that? You can say that?" He said, you can go back to America and they won't throw you in jail?" I said to him, "Yes, I can say that. I am an American, and our Constitution protects freedom of speech." I think that the Soviet censors knew intuitively what struck that young Polish law student immediately, and that was, there was a deeper story here, a frightening story to the Soviet censors. And the story was that this is what freedom of speech looks like. That at its core is the right to criticize the government of the country that you love in the belief that it can do better, and that it needs to do better. I wrote this book and dedicated it to my students in the belief that our country can do better, and that we all need to be rededicated to political pluralism and a marketplace of ideas in the United States that is open and robust and decentralized and independent and protected by the United States Supreme Court under the First Amendment of the Constitution. Thank you.
Thank you so much for those remarks, Mr. Glennon. You gave us some fantastic historical anecdotes, and you talked about some ideas that are a little bit abstract. And I know in your book you have quite a few concrete contemporary examples, particularly in the United States. So I was wondering if you might be able to elaborate on one of those, kind of the context of everything you just talked about.
Sure. One of the examples that immediately comes to mind is the way the United States government responded during COVID. Many of you remember the statements that were made by authorities in the United States. What am I thinking of? Well, almost everything that the United States government said begin at the beginning. Masking, social distancing, how the virus spread, school closings, myocarditis. You go down the list of topics that the authorities addressed, and in most of those realms, the initial statements made by authorities within the United States government were incorrect. They were wrong. They were what is commonly referred to today by the government as misinformation or disinformation if you think it was done intentionally. How did the government respond when efforts were made to correct those falsehoods? And I would point out many experts tried to do that. People like Jay Bhattacharya, prominent epidemiologist from Stanford, and colleagues from Oxford and Harvard, signatories of the Great Barrington Declaration, who posted information on social media that was true in response to this information that was false. What was the response? The response of the government was to try to strong-arm the social media to take down and bury those posts. Understand that this was not false information that was censored. It was true information responding to false information. So now we have a cadre within the government that is again pressing to take on the authority to censor information that the government doesn't like by advising the social media to take it down. They want the United States government to be the official source, a metric by which the accuracy of information is determined. They want the government to be the ministry of truth. I suggest to you that making the United States government, after this record, the ministry of truth is the equivalent of making Christy Milne the head of an animal shelter. No, he ought to be respecting the ability of the American people to handle the truth. And rather than speaking ex cathedra, as though we have, some level of infallibility, rather than speaking ex cathedra, speak with scientific uncertainty, recognizing that we're dealing here with science that is always subject to rebuttal and reconsideration. So I think that's an example.
Thanks. Thank you. And that example is in no small part why one of the cases that we should be getting a decision here from pretty shortly, Missouri v. Biden, which I think has been renamed Murthy v. Biden, here in June, was brought by a series of state governments. And so I wondering if, one, you could give us a brief overview of that case for those that are unfamiliar with it, but also, kind of apply what you've been talking about, the First Amendment, particularly in the, multiple stakeholders when it comes to free speech.
Yes, good, thank you. Well, this episode that I just described is the principal fact situation that has led to this massively important First Amendment case, Murthy, that is now before the United States Supreme Court, formerly Missouri versus Biden. And the plaintiffs are a number of states, principally Missouri and Louisiana, and a number of the plaintiffs that I just described, including the authors of the Great Barrington Declaration, who argue that they were censored in violation of the First Amendment. The administration rejects that argument essentially on the basis of two doctrines. The government speech doctrine, suggesting that under it, the government has a right to express its views on these issues and make recommendations to the social media as to what they should take down. And second, the social media argue that they too have speech rights as private entities that are engaged in curation, which is an editorial judgment that results in a decision to publish or not to publish a classic First Amendment activity. The problem with this view is this. If you think that in this fact situation, the only speech interests to be given any weight are the speech interests of the government and the social media platforms, you have created a situation in which the marketplace of ideas can be closed completely to any information that the government and the social media decide they do not want the people to see or hear or discuss. My view is that can't be right. The First Amendment cannot permit the government and the social media to join forces as they have in what the district court in Missouri v. Biden said is arguably the most massive censorship regime in American history, which the Fifth Circuit affirmed, saying millions of posts that are constitutionally protected, its words, have been suppressed by this regime. The First Amendment cannot be viewed as permitting that to occur. No. You can't, if you're going to have a vibrant marketplace of ideas, take into account only the speech interests of the government and the social media platforms. You have to consider as well the speech interests of listeners and users and the general public. So this is a question now before the Supreme Court. It is, I think, rightly said to be probably the most important First Amendment case of our lifetimes, arguably the most important First Amendment case of all time.
Yes, so staring down a massive censorship regime is a little bit daunting. I was wondering, at the end of the book, you talk about how, you're not out here trying to catalog every single instance of First Amendment issues that arise, but it said prevent a framework or a paradigm for thinking about some of these issues. So, facing down, again, the censorship regime in this massively important case, how would you sum up that kind of framework or paradigm for the way that we should be probably thinking about these issues?
Thanks, Kelly. That's an important point. This is not a book that attempts to answer the myriad questions that arise as a result of the emergence of this new technology. I think that we have to address these questions in the right order and isolate the threshold questions and resolve them first to create a framework within which the remaining issues can be resolved. So what are the threshold questions? I think there are three. First, what body of law should be applied? My answer is, as I've said, the First Amendment, not international human rights law. Second, who should decide how the subsidiary cases come out? Answer, the rules should be set by the courts. It would be nice if you could look to legislatures, namely the Congress, to come up with a new set of rules for online speech. But the sad reality is that our political system is deadlocked. The truth is that because of the censorship that these judges have identified, people are blind to their blindness and are electing representatives who are not responsive to the need to unblock the channels of political communication, which is quintessentially the job of the courts. And the political branches, the president and Congress, are unavailable because the channels of communication, political communication, are clogged, as they are in the United States today. The burden falls on the courts. Clear those channels. And that is the question now before the Supreme Court. And the final issue is one that we just talked about. Whose speech interests are to be taken into account and weighed and reconciled in coming up with the rules for this new regime. And the rules right now are the law of the jungle. There basically are no rules. My answer is no, you cannot look only to the speech interests of the government and the social media as they argue. You have to give effect, some weight, not dispositive weight, but some weight to the rights of listeners and the rights of users of social media who are censored and the rights of the general public. Why? Because this is a central conclusion that I come to in my book. Why? Because ultimately, this is not simply a question about free speech. It's a question about democracy. A lot of people view free speech as kind of an optional add-on. You can have a democracy without freedom of speech. That is wrong. Democracy and freedom of speech both proceed from the same premise that the people are capable of deciding for themselves in an open marketplace of ideas what is true and what is false. And they are able to decide for themselves what is in their own best interest. If you don't believe in that, you don't believe in either free speech or democracy.
Thank you so much. And so with that, I'd like to open up to Q&A from the audience. So yeah, you can go ahead and line up the microphone.
Okay, thank you.
Two right there, yeah. We'll package these up to be a little bit expedient because many ideas out here in the marketplace as possible. So you two gentlemen can go first.
All right, thank you. Is this all right?
Yeah, works great.
All right, thank you very much, Professor. This is very enlightening. A fellow by the name of Vladimir Putin has been practicing 1930s Goebbels models of mixing censorship with propaganda. I wonder what grade you give him, and how do you think that's going to turn out?
Yes, sir, go ahead, we'll take your question now.
Yes, I'm Kent Jones, did my malt here in 1979. So my actually recent research deals with a related issue to what you just mentioned, which is the role of epistemic communities in organizations, functional organizations, institutions like the World Health Organization. So the question is, what is the proper role or organization of a free market of ideas when technical expertise is contested? For example, all the things you said about COVID mistakes, absolutely true. Yet in the end, in a crisis like that, decisions have to be made at the policy level about which science, if you will, to follow. Now, we can exclude, for example, QAnon from the discussion of reasonable views on COVID. But the Great Barrington Group, for example, had very good things to say. There were people on the other side of that issue who also had good things to say. How do we organize the epistemic community's contribution to identifying the things that need to be known in critical cases of, for example, life and death, where what should our face masking policy be? What should the policy be on quarantines and on closing schools, so forth? All of these things are controversial, but we have to come up with an answer somehow. how do we come up with the answer?
Thank you so much. One more, Professor Glennon? I think you were, why don't you go ahead, sir?
Thank you. Question that was posed to the Harvard's president and Congress. The calls for genocide of Jews violate individuals' First Amendment rights.
You start with the first question concerning Putin's propaganda. This is not a new question for the United States. Foreign propaganda has been a matter of continuing interest over the decades. In fact, one of the Supreme Court cases that is most directly on point that the Supreme Court will have to look very closely at in Missouri versus Biden, the Murphy case, is a case that was decided involving foreign propaganda in 1965. It's called Lamont versus Postmaster General. It involved an effort to curb foreign propaganda. Congress enacted a statute concerned that American citizens during the McCarthy era were reading Pravda and Izvestia and being misled, which required Americans who subscribed to this communist propaganda to go to the post office and sign their names on a register affirmatively requesting the post office to deliver this communist propaganda to their homes. This was struck down by the United States Supreme Court, and in a ringing endorsement of First Amendment principles applicable to listeners, the most liberal member of the Supreme Court, Justice Michael Glennon, said the right to receive, the right to hear, the right to listen is integral to the right to speech. And the law was struck down, as I say. Note that in this case, the speaker, Soviet Union, had no First Amendment rights whatsoever. No First Amendment rights. It was decided purely on the basis of the right to listen. Second, the epistemic community is disparate and widespread, and this creates problems because when information is posted online, different segments of that community have different abilities to analyze the truth or falsehood of the information in question. At one end of the spectrum, I don't think you would want to look to members of the epistemic community who could be misled into believing that the cure for COVID is a glass of bleach on the rocks. No. The proper response to evil counsels in that situation, as Justice Brandeis said, is wise counsels. The proper response to bad speech is more speech, good speech. Information injected into the marketplace of ideas that points out that that's a silly idea. So it's useful in situations such as that to allow error to be expressed. And there are other situations where falsehood paradoxically has value. Think, for example, of Trump's claim in the face of incontrovertible evidence to the contrary that his inaugural crowd was larger than Obama. Or Joe Biden's claim that he never, ever spoke to Hunter about his business dealings, about Hunter's business dealings. I think that it's useful for the American people to hear those falsehoods, because that's how you make judgments about the character of a candidate. That's how the political system operates. So when should the state step in and make a judgment that truth should be suppressed? Let's not take falsehood, let's take truth. Truth should be suppressed. I'm not a First Amendment absolutist. I am not a First Amendment absolutist. And I agree with Justice Brandeis that the test is whether the facts present an emergency in which there is no time for good ideas to rebut bad ideas. If somebody, for example, posts a recipe for making an atomic bomb, or a recipe for mixing up new toxic, highly contagious bioengineered smallpox that will wipe out 90% of the population of the United States within weeks, which is, by the way, not entirely hypothetical. No, I say take it down. That's an emergency. That's an emergency. But this is essentially recognized by the Supreme Court in the Brandenburg test. The Brandenburg test distinguishes, this gets to the next question concerning genocide, distinguishes advocacy from incitement. The First Amendment protects advocacy, even advocacy of law violation, even advocacy of violence. The line is drawn at Mark Antony's funeral oration. The line is drawn at incitement. If the speech incites to immediate, imminent violence or law violation, and there is no time for counter speech to contain him, then it is permissible for the state to step in and limit that speech. So this leads to the third question. Is the abstract statement, I think genocide is a great idea, the state of Israel should be eliminated, constitutionally protected? Yes, of course, that's classic advocacy. It becomes incitement depending upon the context. I mean, I hate to bring up a sore subject, but it turns out that the president of Harvard was actually right in her response. These questions, the answers to these questions are heavily context dependent. When a true threat exists, when a statement is made by one-on-one, by an individual directed at another individual, and there is a reasonable expectation of violence, the state is permitted to step in and punish that speech, but not an abstract statement suggesting that the state of Israel should not exist. That is classic protected speech.
Let's take last question.
Hi, Paul Wang, Mo 2017.
Yes, hi, nice to see you again. Thanks for coming.
Very happy to see you. I have a question about TikTok. The Congress has just passed the bill to force TikTok to sell unless in diverse from Chinese ownership. And most likely Biden will sign it in the days, very soon. And that case, they're bringing it to the court, most likely going to end up in the Supreme Court. The justification for banning it is owned by the Chinese, and also some politicians have now go to the argument that it is inciting American, especially teenagers, to the pro-Palestinian cause, which of course were absurd because the American we knew that even without TikTok, that would have been the case. But what is your view on this Congress passing this bill, which is kind of unprecedented, and also what would you think is going to happen in the court, especially the Supreme Court, when this case is definitely going there?
I think it's not unprecedented. It's close to being on all fours with the Lamont case that I just described. And the likelihood is very high that this would be struck down as unconstitutional based upon the right of the listener to select what social media platform the listener wants to listen to. Thank you.
Thank you all for coming out. Absolutely fantastic. To see you all here. We have a representative from the bookstore, I think, will come down and if you want to buy a book and get it signed. Professor Glennon will be here for 20, 30 minutes.
Thank you all for coming.